All right, hi, welcome back. Attorney Steve Vondran here. Welcome to another exciting video. So we are talking in this video about Strike 3 holdings. This is a case out of Central District of California. These are federal courts. This is where copyright cases are brought. Exclusive federal court jurisdiction. Here is a ruling that just came down from the United States Magistrate Judge Sherry Pym. And usually the magistrate judges in a federal court case, they handle discovery disputes. And as you can see in this case, there was a discovery dispute. Basically, if you decide to dispute your Strike 3 holdings infringement case that's brought as a copyright infringement case, after your case gets going, after a scheduling conference and whatnot, you are able to engage in discovery. Now, discovery can take many different forms, from a deposition to requests for admissions, admit or deny things, special interrogatories where you're answering questions, and requests for production of documents. That's where you can ask for documents, but you can also ask for an examination of the opposing party's hard drive in these cases. So this is a case that I'm going to read you the decision. It's only 6 pages, so bear with me. But it's a really important case because this shows where plaintiff tried to seek the hard drive and cloud information, cloud data stored up in the cloud of defendant who was accused of infringing movies. These are the Vixen, Tushy, and Black movies of Strike 3 holdings. So let's take a look at this. The court ultimately, I'll just jump to the chase in case you're wondering, the court said that you cannot just go and demand the hard drive and demand all the cloud data. It's overbroad, it's not proportional to the case, and that there's better ways to do it. So if you want to follow me, that's kind of the general holding of this. But let's take a look. On October 21st, 2021, plaintiff Strike 3 Holdings filed a motion to compel. This is when they don't provide the evidence, and I'm going to interject a little bit. This is when they don't provide the evidence that you're looking for. If you can't agree following a meet and confer conference, you can file a motion to compel the discovery. So that's what happened here. Motion to compel defendant John Doe. These are unknown defendants sued by the name John Doe. Responses to its requests for production, number 1 and number 15. So they sought, and 2 of their requests were number 1 and number 15 in their request for production of documents. The motion is supported and opposed in a joint stipulation. So you put together a joint stipulation. The defendant was opposing this. Plaintiff's arguments are supported by the declaration of its counsel, Lincoln Banlow. He's with the Banlow Law Firm. We deal a ton with him. We handle most of the California Strike 3 cases, Northern and Central District, and Exhibits 02, and the declaration of its computer forensics expert, Patrick Page. Defendant's position is supported by the declaration of his counsel in the Exhibits 02. Plaintiff filed a supplemental memorandum on November 16, 2021. On the same day, defendant filed a supplemental memorandum supported by its own declaration. The court held a hearing on the motion on December 7, 2021. After considering the parties' arguments and the evidence the authorities cited, that's your case law, the court now denies plaintiff's motion to compel. So they filed a motion, the court denied it. Plaintiff is the owner of Adult Motion Pictures. The motion pictures are distributed through various adult websites and DVDs. Plaintiff alleges that a defendant used the BitTorrent protocol to download plaintiff's motion pictures and distributed them to others, committing copyright infringement. As relevant here, June 9th, plaintiff served defendant with his first request for production of documents, including RFP number 1 for a forensically sound copy, a mirror image of the hard drives, and RFP number 15 for a complete copy of all the files contained within any of his cloud-based storage system. So you can see just right off the bat that appears to be very, very overbroad, and you could end up scooping in private information. Banlow declaration on August 3rd, 2021, defendant objected, indicating the requested materials contain private, family, and financial data, as well as information protected by the attorney-client privilege and the spousal communication privileges. Now, in case you don't know, I should probably do a video on this. I'm going to write it down right now as we're talking. But the spousal communication privileges prevents one spouse from having to testify against another spouse. Okay, that's protected communications. On August 17, 2021, in a letter attempting to address the discovery dispute, plaintiff counsel proposed an ESI protocol, that's electronically stored information, to which defendant objected on August 18, 2021. Banlow In his objection, defendant offered to produce files subject to a list of search strings. So they wanted to the defendant said, well, instead of just handing you all the entire enchilada here, why don't we just do little search strings? Like maybe we look for Tushy, maybe we look for Black, maybe we look for Vixen movies, things like that. The parties met and conferred. That's an obligation before you file a motion in federal court, September 2nd and September 9th, but unfortunately unable to reach an agreement. So here's the court's discussion. Plaintiff requests the court to compel production of defendant's hard drives and cloud-based storage systems for a forensic examination. Plaintiff argues that the information contained therein is relevant to both plaintiff's copyright infringement claim and also to defendant's affirmative defenses. Plaintiff also argues the forensic examination is proportional to the needs of the case, given that the burden on the defendant is minimal, since he already created mirror images of his hard drives and the cloud accounts. So here's FRCP, Federal Rules of Civil Procedure 34, allows discovery of electronically stored information, which is limited to any non-privileged matter that is relevant to any party's claims or defenses and must be, as you can see here, proportional to the needs of the case. And this is where strike 3 went wrong here. FRCP 34A 26B1. The advisory committee noted that Rule 34A is not meant to create a routine right of direct access to a party's electronic information system, although such access might be justified in some circumstances. In determining if a forensic examination of all electronic devices is warranted, courts consider whether the examination will reveal information, here it is, that is proportional to the needs of the case, given any possible privacy or confidentiality concerns. There's your buzzwords right there. If you're writing the motion, you're opposing. Say, well, it's not proportional to the needs of the case, possible privacy and confidentiality concerns, privileged documents, so forth and so on. A couple cases cited here, Henson versus Tern, denying a request for forensic imaging of devices because it may reveal information that is not relevant or privileged and implicates significant privacy concerns. Here's your buzzwords if you're writing the motion in opposition. Northern District case from California, the Brocade Communication System case versus A10 Networks, allowing forensic inspection of computer hard drive where the electronic information is relevant to the pending claims, okay? 1. A forensic examination threatens the disclosure of irrelevant and privileged information. Plaintiff first argues that the mirror images of defendant's devices and cloud accounts are relevant to the plaintiff's claims and to defendant's own defenses, that there is no question that the examination of these images would reveal information relevant to either proving or disproving plaintiff's case. But, I love the word but, that always tells you something, but providing a complete forensic imaging of defendant's hard drives and accounts will also disclose information that has no relevance to plaintiff's copyright infringement claim, including family photos and personal financial information. So in a way, it's kind of an overbroad request. Too much stuff that would come out. Citing the Henson case, finding a complete forensic imaging of cell phone threatens to sweep information bearing no relevance to the case, listing cases standing for the same proposition. So the Henson case is a good one with seeking the imaging of a cell phone. It would also likely reveal privileged information. The stating the hard drive contains attorney-client communications. So if they're seeking all this information, they could very well get communications between you and your attorney or you and your spouse and things like that. Plaintiff said, however, that you can get just a protective order would prevent the disclosure or privilege of otherwise private materials. And I believe I have a video on protective order. If you Google Attorney Steve protective order, I believe I do. Specifically, plaintiff proposed the following protocol in the event its expert discovers privileged information. So here's what the Banlow law firm put forward. Here's what we should do, he says. If plaintiff's expert examination reveals relevant information matching the search criteria listed in 10A to E or 11A to D above, but the relevant information is privileged, then plaintiff's forensic expert will, without disclosing the contents, notify both plaintiff's counsel and defendant's counsel of this discovery. So they had a scheme where the examiner would figure out if something was privileged or not. So that's kind of, I don't like that because a forensic examiner is not a lawyer. I don't think they really know what is confidential, what's attorney-client, what's spousal. It just puts a big burden on the forensic examiner. It's not really their job. Defendant will determine whether defendant wishes to assert a claim of privilege to the information. And plaintiff reserves the right to move the court for an in-camera, here's a good one, in-camera inspection of a document that the defendant claims is privileged. Now, in-camera just means in like judge's chamber, and it's not open to the public. It's not made a part of the record. It's in-camera. It's a great word. Inspection of a document. Now, neither plaintiff's forensic expert nor any other person's view of privileged information nor any inadvertent disclosure thereof will constitute a waiver of any privilege by defendant. So they're saying, let's do this, and it's not a waiver, and so forth and so on. However, court didn't like it. Plaintiff's proposed protocol does not adequately address defendant's legitimate privacy and privilege concerns. For example, the protocol provides for plaintiff's expert to make the initial determination of which may be privileged. Other courts have rejected similar protocols that provide even more protection than plaintiff proposes here. Cite the Brocade case. Plaintiff posted an inspection, search, and production protocol that takes many steps to protect defendant's confidential and attorney-client privileged information. For example, by requiring that the forensic expert produce any recovered files to defendant first, to allow its counsel to review the files as to relevance, responsiveness, and prior privilege prior to any disclosure of the plaintiff. This is what we call the right of first look or the right of first review. That's where, as an attorney defending someone in a strike 3 copyright case, I would say, well, I want the right to first look. I'll decide what's privileged and what's not. I'll decide, and will create a privilege log. And then if you want to challenge it, you can. But this is what they're talking about. The court in Brocade found that plaintiff was not entitled to set the conditions of the inspection unilaterally by themselves, nor to select the person who will perform it. There's a Northern District case, Northern District, California, Advante International versus Mintel Learning Tech, where the court found the defendant failed to show it would be appropriate to allow its retained expert to conduct a forensic examination of hard drives absent an examination protocol. Because plaintiff's protocol does not adequately address defendant's privacy, confidentiality, and privilege concerns, a forensic examination of defendant's devices threatens the disclosure of irrelevant and privileged information. So there it is again. You get the feel here. Plaintiff additionally argued that the forensic examination is proportional to the needs of the case, and here's their argument. 1, plaintiff's claim implicates important property rights, intellectual property rights, copyrights. The amount in controversy in this matter is large and growing. 3, information asymmetry favors production. 4, defendant's resources are not at issue and plaintiff will bear the cost of the examination. 5, the hard drives are critical to resolving plaintiff's claims and those defenses. So there were the arguments for proportionality. Plaintiff also contends the only risk in permitting a fulsome review that plaintiff's expert might uncover private information about Doe not germane to this copyright dispute is accounted for by the protective and clawback provisions. There's another great word, clawback provisions set forth in plaintiff's proposed ESI protocol. Plaintiff is correct. There's virtually no financial burden to defendant if we have to simply turn over copies of images already made. But, here it is again, while questions of proportionality often arise in the context of the dispute about the expense of discovery, proportionality is not limited to such financial considerations. Privacy interest can be a consideration in evaluating proportionality, particularly in the context of a request to inspect personal electronic devices. You have the In Re Anthem cases where the courts weighed the privacy concerns in determining whether forensic imaging was warranted. It's another Northern District case out of California, denying access to computer systems in light of privacy implications. So this even gives you some great case law to cite if you're in a case and you're opposing strike 3 holdings, seeking forensic examination. You got the Boston Science Corp versus Lee, another Northern District case. And as you can see, we're in a Central District case, but you are able to cite Northern District cases. Reasoning forensic imaging remains highly invasive and engenders the risk of unanticipated accidental disclosure of crown jewels. Love another great word, crown jewels, pronounced in competitor versus competitor litigation. So, if you're a competitor facing competitor and you ask for the whole hard drive and get it, and the cloud data, you're going to get so much stuff. You may get the crown jewels, trade secrets. You may get all kinds of things. So plaintiff argues its request is proportional because it has no other way to obtain defendant's file. This is a common argument. I have no other way, Judge. There's just no other way. Court disagrees. Defendant has suggested a number of ways plaintiff could obtain the information it seeks, including the use of ESI search strings. That's where you say, well, let's just search for certain things and let's see what we find. It is possible defendant's expert could conduct such searches within plaintiff's expert present, so the two could work together to refine searches to obtain the relevant information. This I like better. We're working together to limit what we're actually searching for. The parties disagree about whether it is possible to adequately conduct such search for movies with names that may have changed, among other factors. Got declarations in here. Counsel Edmondson for the defendant has a declaration. But plaintiff did not even try here. Say that again. But plaintiff has not even tried here. As such, plaintiff fails to show that a less intrusive option would not yield the information that it seeks. A less intrusive option. There's another nice buzz phrase. Okay. Here's a Tingle versus Herbert, Louisiana case, looks like. Middle District of Louisiana. 2018. Before defendants could get access to the plaintiff's cell phone, they were required to show an attempt to obtain the information by less intrusive means. There's your buzzwords. So you got the buzzwords if you want to oppose. Undoubtedly, a complete forensic examination would be more reliable and thorough way for plaintiff to ensure it has obtained all relevant information. But given what is at issue in this case, the alleged infringement of 54 movies, requiring defendant to turn over images of his hard drives and cloud accounts to plaintiff is not justified. There is no indication defendant willfully defaulted on his discovery obligations. Absent specific concrete evidence of concealment or destruction of evidence, courts are generally cautious about granting a request for a forensic examination of an adversary's computer. Got some more case law here. It's from the Southern District of California. So we got cases from the Northern District, the Southern District. Mere skepticism that an opposing party has not produced all relevant information is not sufficient to warrant drastic electronic discovery measures. So there you have it for all the reasons plaintiff's requests denied hard drives, cloud-based storage accounts, not proportional to the needs of the case. Therefore, ordered plaintiff motion to compel defendants' responses to RFP number 1 and 15 is denied. Okay, so there you have it. So really good case. If you're dealing with strike three holdings and they tell you, we're going to examine your whole hard drive and your cloud accounts, we're going to do all that, and your cell phone, all your contents. So there you have it. General legal information only, not legal advice. This is straight from the magistrate judge in the Central District of California. If you need help with a strike three case, I can't think of a better firm than Vondrand Legal. You can find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. It is important to point out that we were identified by unicourt.com as the #1 copyright infringement defense firm in the United States for the year 2020 in regard to number of cases handled. We are number 15 on the Lex Machina list of copyright plaintiff counsel in the United States in accordance with number of cases handled. So we have experience. We've worked with this firm quite a bit. If you need some help, give us a call. If you received a subpoena notice from your ISP, Cox. What other ones do we have, Lisa? Cox, Charter, Frontier, AT&T, Comcast, Verizon. Frontline Lisi, ladies and gentlemen. She is your frontline when you call our firm. You will get the most knowledgeable, most informed Frontline Lisi. So there you have it. I hope you enjoyed this. If you like it, give me a like. If you have any comments, put them down below. If you want to subscribe to our channel, we're going to hit 50,000 this year. That's our goal. We're going to hit 50,000 subscribers. We're at 33,000 now. Make sure to hit that subscribe button. Learn something about the legal system. What are you going to learn in politics anyway? I got to go now. Take care. Happy New Year.